Right. Well, good morning, everybody. I hope that those of you who are in the audience can see everyone and can hear me in particular. And I'm delighted to welcome you all to this webinar presented by Six Pump Court. I am Stephen Hopman, the head of Chambers, and as I say, I'm absolutely delighted to welcome you to the first in a series of what we hope will be 3 webinars. In the early part of next year, we will be hosting a webinar on international arbitration and climate change, and also a webinar on international construction disputes. But this morning, members of our arbitration team will be speaking about international arbitration awards, challenge and enforcement. And I think I can promise you a varied and intellectually stimulating program. Let me mention that the webinar is being recorded, so you will have the opportunity to watch it all again if you wish to do so. And we will be having a question and answer session towards the end. So as and when questions occur to you, may I encourage you please to type the questions into the Q&A box. And when we get to that point, I will put the questions to the panel and invite them to give their answers. So don't wait until the end. Do by all means put the questions in at that time. Each panelist will speak for 10 minutes or so, maybe a little more, and that will give plenty of time for questions at the end. As you know, we're aiming to finish by about 12:15. So I have pleasure now in introducing our first speaker, who is Paul Mcgarry. He is a senior counsel of the Bar of Ireland, also a member of the Bar of England and Wales, and a member of the Bar of Northern Ireland. Frequently appears not only in the courts in Ireland, but in courts in Europe as well. And he has developed a significant international arbitration practice. And he's going to talk to us about international arbitration, a solution to Brexit enforcement issues. Paul, the floor is yours.
Many thanks, Stephen. I hope everybody can hear me, and I'm sure you'll tell me if you can't. I just want to talk a little bit about what might happen after January 2021, and in particular, my thesis that arbitration presents an ideal solution to some of the enforcement issues that might arise. At the moment, as we know, London is the global centre for dispute resolution. In fact, London is also the second biggest centre for EU legal services, both advice and representation. And you can see why that is: the certainty of the common law, the quality of the judges, the independence, and so on. Mostly this has been in the area of litigation, but also London is one of the leading centres for arbitration. So at the moment, because we're in a transition period up until the end of this year, European measures and principles will still apply. You have Rome I regime, as it's called, based on now regulation, previously the convention, which governs jurisdiction choice in the area of contracts. Rome II, which deals with non-contractual obligations. And then you have Brussels I recast, which relates to the uniform enforcement of judgments. There are also a number of other measures, including things like standard European enforcement orders, in summary, and undefended cases. In January 2021, obviously that's all going to change, those rules won't apply, but there are some alternatives available. The Hague Convention on Choice of Court and Jurisdiction is one, which replicates some of the Rome I and Rome II provisions, not to be confused with the Hague Convention on Child Abduction. The UK has in fact already acceded in September 2020 to the Hague Convention. There is in fact also a Hague Convention on Judgments, but I think that was only finally agreed in 2019, and I don't think any country has ratified at the moment. The Hague is not a purely EU measure, although those that have ratified it are the existing EU member states, together with I think Mexico, Singapore, and Montenegro. Then you have the Lugano Convention, about which I suspect practitioners have heard quite a lot in recent months. That replicates Brussels I, but in fact doesn't replicate the recast Brussels I. And I'll come back to what that means perhaps in a moment. In respect of the Lugano Convention, it is an agreement as between member states of the European Union and the EEA and Switzerland. The UK has said that it will join, but the decision is not a unilateral one, unlike Hague. The UK has already secured support from Iceland, Norway, and Switzerland. But as we'll see in a moment, that the EU is attempting to tie accession, or its agreement to UK accession, to the free trade agreement that they're trying to negotiate at the moment. So there are some, as I said, problems with this regime and how this might work. The European Commission published a notice in August 2020 when it's disputed whether jurisdiction clauses entered into before the end of this year are and remain outside the scope of the Hague Convention, so still fall to be considered under the national laws of the EU 27. The UK government disagrees strongly and says Hague applies actually from the date of EU accession in 2015. There's another problem with Hague. It relates to exclusive jurisdiction choice only and doesn't apply to asymmetric jurisdiction clauses. These are not that uncommon in financial services, large banking contracts, where the exclusive jurisdiction choice is confined to one party, typically the borrower, whereas the lender is given a wider choice of where to sue. And as I said a moment ago, in relation to Lugano, Lugano has been linked by the EU negotiators, at least, to the conclusion of the FTA agreement. So that's still a little bit up in the air. No matter what happens, the time in which the UK can join Lugano has, in time for it to be enforced by the 1st of January, has already expired. So there will be a lacuna no matter what happens. So this leads me to the conclusion that international arbitration is an ideal answer in the context of any intra-EU or as between outside states such as the UK or the United States and counterparties within the EU. And why is that? Because it's unaffected in principle by Brexit. Obviously, we know international arbitration is popular because it's confidential, neutral, and offers considerable flexibility. Two things make it stand out, I think: the speed at which you can obtain redress, and secondly, the fact that there is no real right of appeal based on very well established institutional rules, and even the case law relating to ad hoc arbitration. Enforcement is based upon the 1958, in most cases, the 1958 New York Convention. There are 157 at the last count jurisdictions that have signed up, including all 27 EU member states and the UK. The reciprocal enforcement obligations that are set out in Article 3. There's very limited scope to avoid enforcement, identified in Article 4. There's even a model law attached that many, many states, including EU member states, have adopted. The New York Convention is, of course, recognized in the 1996 Arbitration Act for enforcement purposes specifically. So from the perspective of Brexit, there are no enforcement problems with the EU in principle. Because, as I said, the New York Convention makes enforcement relatively seamless. And James Clanchey is going to come back and talk about a couple of issues relating to that in a few moments. In addition, within the EU context, the Court of Justice already recognizes the value of arbitration in intra-EU disputes, and that's evident from a wide number of cases before that court. So it follows that London will continue to dominate, even if one of the counterparties is a resident or domiciled in an EU member state. And given that there are going to be significant problems with Hague and Lugano in the context of court proceedings, there's likely to be a big increase in arbitration as an alternative to that. Also, given that the UK is no longer subject to EU rules, we might even see return of anti-suit injunctions. Even if the UK joins Lugano, for example, Lugano is based on the previous version of the Brussels I regulation, not the recast version, which was put in place to deal specifically with the problems associated with arbitration and the now infamous Italian torpedo. So that's my overall impression of where you end up having regard to the issues that might arise. There's one perhaps very small chink in the arbitration issue, and that's where an arbitration may concern or be concerned with an issue of pure European law. And I suspect that's something that's going to be very, very rare. There is a question about the capacity of arbitral tribunals to consider issues of European law after January 2021. Particularly where those tribunals are located or seated outside the territory of the European Union. And obviously there may be knock-on issues of enforcement within the EU based even on the New York Convention. As I said, I think those cases would be very rare, but it's probably worth keeping an eye out for practitioners as to what might happen. If you look at paragraph 54, for example, of the infamous judgment of the Court of Justice in Acmea in Slovakia, it comments upon, in particular, the obligation and the need for in EU law for the court review process to be capable of being a subject of a reference to the Court of Justice. But again, as I said, I think that's a very small area. And I think practitioners would be wise to keep an eye on the disputes themselves, or even when you're preparing the terms of the dispute or identifying the basis of them, to keep an eye out for issues of European law. As we know, the vast majority of European law is public law in nature anyway, and is unlikely to give rise to much in the way of dispute in the context of arbitration. So, Stephen, thank you for that. I hope I haven't exceeded my 10 minutes, and I'm happy to hand back to you. Thank you. You're on mute.
Thank you very much, Paul. Your timing is perfect. And although I've myself have already got about half a dozen questions that I'd like to ask you, I'm not going to take time to put them now. I do encourage everybody listening, please, particularly those who've joined since my introduction, to think about questions that they'd like to raise and to type them into the Q&A box so that we can deal with those in due course. But from the intellectual heights of Dublin, we're now going to cross to the equally impressive intellectual heights of Warsaw. And I'm going to invite my esteemed colleague, Chemko. That's how we always refer to him. And I hope he won't mind me calling him that for the purposes of this webinar. So Chemko, you're in Warsaw, I think. I hope the weather is fine there. And we're looking forward to hearing you talking about due process, the right to be heard in virtual hearings. Over to you.
Thanks very much, Stephen. Good morning, everybody. Thanks very much for finding time to listen to my presentation. In general terms, I would like to tackle the issue of the enforcement from the perspective of the virtual hearing. And recently, in July 2020, the Austrian Supreme Court issued a very interesting award confirming that virtual hearings could be run and are not in contradiction to the rights of the parties. The background of the case was that the tribunal ordered the virtual hearing while one of the parties questioned this. And then this party filed the claim against the award in Austria, claiming that the tribunal became that the tribunal was not able to order this, and just the rest of the proceedings were not fair and have not put the parties in the right format. And the court said, and I will just read it, that ordering virtual hearing against the will of one party was not per se against Article 6 of ECHR and admissible and compatible with the principle of fair trial pursuant to Section 594 of the Civil Procedure Code of Austria. Such principle not only guarantees the party's right to be heard, but also access to justice and hence effective legal protection. If we look into the realities, after the breakup of COVID, everybody just moved to virtual hearings. And then there were some questions whether you can run those or not on the basis of provisions of institutional rules and also on the basis of the provisions of the local regulations, local laws. And we had the case exactly, I mean, I had the case where we proposed the virtual hearing and one party objected. So finally, we decided that, okay, we will not go the route of the tribunal which was taken in the Austrian case, but we proposed the hybrid hearing. It means that we will just meet in the normal courtroom, and whoever wants, it will take part virtually, whoever wants would take part in person. Interestingly enough, as time went and the number of COVID cases increased in Poland, finally, everybody was happy with the virtual hearing. So I touched this problem somehow personally with the easy solution, but I have found this Austrian case very telling and very helpful. Now, the next issue would be that if we look into this situation from the due process point of view, there are two basic elements. The first one is when the tribunal, if and when the tribunal has the right to order virtual hearings. And the second is how such a hearing just meets the requirements of the due process per se. I looked into two sets of regulations. One is Arbitration Act of 1996, English Arbitration Act, and the other one is Ancestral Model Law, which is a kind of the proxy for arbitration laws in many jurisdictions in Europe and elsewhere. Generally, both sets of regulations provide that, in fact, unless the parties agreed otherwise, then the tribunal has the right to order simplifying whatever it wants as far as the procedure is concerned. So, in fact, if we have just any party objecting, then the decision of the tribunal in the Austrian case seems to be in line both with English Arbitration Act and ancestral regulations, which are more or less the same as Polish arbitration law, Austrian arbitration law, etc. However, I have just found some interesting small differences, which maybe are not very significant, but could have the impact in very specific situations. And if we look into ancestral model law, it says about full opportunity of the parties to present the case. While if we look into the English Arbitration Act, it only says about the reasonable opportunity to present the case. The question whether this is theoretical difference and what is the interpretation is just subject to practice, in fact, and just the case law. I'm not going into that, but simply I'm drawing attention that if we are dealing with any individual regulations, probably we should look into this in more details. One of the interesting things which poses the question is probably, what if both parties agree to virtual hearing, but we have the tribunal which is opposing this? Well, then such tribunal has the right to order the hearings against the parties on whatever basis, say that they are fearing COVID or whatever else, or not. If we say not, then the question is, what about the proceedings? Because then either we have the situation that the arbitrators are not fulfilling their duties and not just running the case in a reasonable time and just postponing it, or we have the case that they are just against the will, acting against the will of the parties. So again, this is something to consider, and I think there is no simple answer to that. At least in my case, we just bought to the idea that the parties will prevail, and we are happy to take the COVID risk and go to the courtroom and serve the purpose. Sorry, I'm just looking into my time. Okay.
Yes, you're fine for time at the moment. Thank you.
Yes. So the next issue is just the due process per se. And then, as you probably noticed from my just English accent and the grammar, I'm not the native speaker. So each time I'm just approaching any case or any text, I'm always just trying to find out the definition of particular terms, etc. I looked into the definition of due process according to the Webster dictionary. And again, I would say that if you look into the synonyms, there are just two groups. The one is that the due process, or due, the word due is defined as just, justified, rightful, warranted. The other one is condign, competent, merited. So I think that again, from my perspective, there are two things that we should look into when we are just thinking about this. Then, in fact, we have the situation how the virtual hearing compares to the hearing in person. It means whether the parties has the opportunity to present the case, to cross-examine, what is the situation as far as the control of the witness is concerned, what about communication, if there's any breaks which put into question whether the process is run in a proper way. One of the ways of dealing with that, despite the experience and sociological skills of the arbitrators, is just to have the proctoring of the witness. Again, if we are talking about what I call extra big cases, where the parties, let's say, are able to put the resources for running the process in such a way, this would not be a problem. However, if you are talking about the smaller cases where you have the situation when the witness is just maybe even not on the other side of the world, but quite far apart and is not ready, or it's not possible that he would come to the hearing, the question is who will cover the costs and how this would impact the overall cost of the proceedings. So these are, again, the issues that should be considered. And again, from my perspective and from my experience, I have found virtual hearings pretty nice and pretty helpful. Although sometimes I have doubts whether my skills to read the screen and just see what's going on in the background are correct, and whether my judgment is correct. So we had a couple of discussions also about the creditworthiness of the witnesses in this situation. So probably these are the issues I wanted to tackle, and I'm just happy to answer any questions. A kind of the summary is that we are in a position that in majority of cases, I think we should, could, and be relatively safe in running the virtual hearings from the perspective of the enforcement proceedings. However, we would need just to look into all the details, also into the situation when we have the people spread all over the place. So also the law applicable to the particular hearing could be much more complicated than in the normal case when you have all the people subject to one hearing jurisdiction law. Thanks very much.
Thank you very much, Chemko. Now I'm going to turn to James Clanchey, who, as many of you may know, was at one time the Registrar and Deputy Director of the London Court of International Arbitration, the LCIA. Since 2016, he has been in independent practice as an arbitrator, and he's going to talk to us about the LCIA Arbitration Rules 2020, enforcement hazards, and tips to avoid them. So over to you, James. Thank you.
Thank you, Stephen. And thank you also to Paul and Chemko for having set the scene rather beautifully, because what I would like to talk about is, first of all, the New York Convention, which is indeed an absolutely brilliant convention, which has been accepted almost everywhere in the world and eases the enforcement of arbitration awards. But I also would like to talk about a decision of the Austrian Supreme Court, which was not nearly as helpful to the reputation of arbitration, in my view, as the more recent and extremely interesting decision that Chemko was talking about. The issue then that we are looking at going into 2021 is how European courts will treat arbitration awards coming from the UK. And it so happens that I had experience of precisely this issue back in 2008, when I had become the registrar of the LCIA. It was actually in my very first week in post that our casework administrator brought me an award to sign. Well, more precisely, she brought me a number of bound copies of an award, the original of which had already been signed by the 3 members of the tribunal. Each of the copies had a stamp on the front page with the usual wording certifying that this was a true copy of the original, and it had a space for my signature as LCA registrar. Now, I felt quite excited about signing this certificate because this was actually the first opportunity for me to use the gift that I had received from my old law firm on leaving, which I'm allowed to use a prop, I think. This pen, this very pen, which these days I use for signing awards that I've written myself. But in those days, I used for signing certificates. Anyway, I felt quite satisfied that the stamps, the signature, and the rather magnificent LCIA seal on the cover of the document would help the successful party to obtain the monies awarded to it by the 3 distinguished arbitrators. Now, this had actually been an ad hoc arbitration which the LCA had administered under the Untitled arbitration rules. It wasn't an institutional arbitration under the LCA's own rules. So the cover of the award was a bit different from the standard LCA cover. It had Untitled in big letters on it. Anyway, I was taken aback to learn some months later that my certificate had not passed muster with the Austrian Supreme Court. The court refused to enforce the award, finding that my certificate did not meet the requirements of Article 4 of the New York Convention. The court had studied the LCIA arbitration rules, Article 26, which deals with awards, and it had noted that Article 26.5 of the 1998 rules, as they then were, did not stipulate which organ of the LCIA was to certify copies of awards. It concluded that the so-called registrar had no power to certify copies, and that only the president or vice president of the LCA court was competent to do that. Now, it's not clear why the court looked at the LCA rules when the award before it was not an award made under the LCA rules, but an award under the Untitled rules. However, its strict analysis of the provisions of the New York Convention, Article 4.1a, which provides that a duly authenticated original award or a duly certified copy thereof should be filed. There's no doubt that the court could not be faulted on its interpretation of the New York Convention. But there was consternation in London that a senior court in a fellow EU state should treat an LCIA document in such an unfriendly way. One of the advantages of going to an institution, even for the administration of an ad hoc arbitration, is that you do get a nice document with the institution's stamp, literally with its stamp on it. And that should help with enforcement. But the Austrian Supreme Court took a strict view of the provisions of the New York Convention. What it found was that my signature did not amount to any kind of authentication of the signatures made by the arbitrators. What Article 26.5 of the LCA Rules 1998 said was simply that the LCA court, in the person of its registrar, would transmit certified copies of the award to the parties. It didn't say anything about authentication. So this problem was then cured in the 2014 LCA arbitration rules with the provision that the award transmitted to the parties would be authenticated by the registrar as an LCA award. Now, I was a little bit skeptical myself about whether that was something that the registrar could actually do. But the fact is that the New York Convention, and this is one reason why it is rather brilliant, is silent as to what constitutes authentication. It's up to the enforcing court to take its own view. So why shouldn't the LCA adopt its own interpretation and simply state that the registrar had authority to authenticate an award as an LCA award? So that is now a provision in the LCA rules. But I have a tip here for anyone dealing with the enforcement of awards coming from England, and that is long before the award is actually in your hands, try and find out what the enforcing court's view is of how those provisions in the New York Convention in Article 4 should be interpreted. Precisely what kind of stamps, signatures, ribbons is it going to be looking for? And I would suggest that you try to obtain more than one original of the award. Warn the LCA Secretariat in advance that that's what you would like to have, because you might need a pristine original, which you can then have authenticated by a notary or in some other way at a later stage. But of course, we're now moving into the post-COVID as well as the post-Brexit environment, where electronic communication has become the norm. And indeed, electronic signatures are being used more and more often. The new LCA rules, the LCA Arbitration Rules 2020, which came into force on the 1st of October, are extremely advanced. They have brought procedure up to date, and they give priority to electronic communication. So they still provide that the registrar may authenticate the award, but now the transmission of the award is to be by electronic means, not in paper form, although it may also be done in paper. In the event of any disparity between electronic and paper form, the electronic form shall prevail, which is quite a novel rule. Anyway, the LCA's willingness to embrace modern technology is admirable, but it may not be shared in every enforcing court. So my advice to anyone dealing with an LCA arbitration would be to request hard copies as well as electronic versions of the award, because an enforcing court may expect hard copies. Now, the LCA rules also now provide in Article 26.2 for the possibility that the tribunal may sign the award electronically. This appears to be unique. The ICC in its recent new rules hasn't actually provided for that. And of course, again, an enforcing court may be quite surprised to find electronic signatures rather than wet ink signatures. And if the LCA is standing out as such a rare institution in allowing it, you can see that judges in some enforcing courts may simply think this was too exotic. So again, if a tribunal is proposing to sign electronically, admirable again as the LCA's ambition is in this respect, my advice would be to seek the other side's agreement to a wet ink signature. And if that fails, actually ask the LCA court for a direction in that respect. Finally, in relation to electronic communications, the LCA rules contemplate that all notices and correspondence in LCA arbitration should be sent by email or other electronic means, unless permission is obtained from the registrar. And here, looking at Article 5 of the New York Convention, you need to be careful that the respondent who may not participate in the arbitration has been given proper notice of the arbitration, which is a requirement of Article 5.1b of the New York Convention. And again, some enforcing courts may not consider that an email communication is adequate notice. So again, my tip would be that if in any doubt, obtain the registrar's permission to use other methods of communication as well. And then looking forward, if you are intending to be using LCA arbitration in the future, put into your contract an additional clause on top of the LCA's recommended clause, an additional notice clause, which will set out the email addresses which should be used for communications. That could help to persuade a foreign enforcing court that notice by email was not only an exotic idea that the LCA allows, but it was actually contractual, and that should definitely help. And as it happens, for a precedent for that notice, I would hope that the LCA itself will produce a recommended clause. But in the meantime, I would recommend the LMAA arbitration notice clause, which sets out how to provide for particular email addresses and what to do if they should change during the course of the contract. So those are our tips on how to address the reforms in the LCA rules, which are definitely heading in the right direction, but may in some respects be going a little too fast for some enforcing courts, even if the Austrian Supreme Court in its recent judgment on virtual hearings has shown that it too takes a modern approach. Thank you.
Thank you very much, James. And it's a relief to hear that there may still be some role for your magic pen. It would be a pity if that were to become completely redundant. Now we're going to move to my colleague, Anthony Connaty, who is a member of the Bar of England and Wales, specialising in international dispute resolution, acting as counsel, as arbitrator, and as mediator. and he is going to talk to us about matters such as challenges to arbitration awards in various ways. And because we're overrunning very slightly on time now, I'm going to turn immediately to Anthony. The floor is yours.
Thank you, Stephen. Yes, I'm going to look at challenges to international arbitration awards under the provisions of first the New York Convention and then the English Arbitration Act, and then thirdly look at the issue of anti-arbitration injunctions and anti-suit injunctions. By way of illustration in relation to each of those categories, I'm going to refer to 3 cases in which I've acted either as counsel or as arbitrator. But arbitration is a confidential process, and generally arbitration awards are not made public, but there are exceptions. For example, where an award or some aspect of an award is made the subject of proceedings in a national court, and then the matter is within the public domain. And the 3 cases to which I am going to refer were subject to national court proceedings in London, Lagos, and Shanghai. First of all, the New York Convention. Paul and James have referred to the convention. Commonly known as the New York Convention, applies to the recognition and enforcement of foreign arbitral awards. Article 1 of the convention provides for the recognition and enforcement of awards made in the territory of a state other than the state where the recognition and enforcement is sought. And Article 5 of the convention sets out the provisions relating to recognition and enforcement. I just refer to 2 of the grounds which are relevant to one of the cases I'm going to mention. That the provision there is that the parties to the agreement referred to in Article 2 were, under the law applicable to them, under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it to, or failing in any indication thereon, under the law of the country where the award was made. And then D, the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. And Paul has mentioned how many states are now, how many state parties have acceded to the convention. I'll go a bit further than Paul. I reckon it's 166, but I may be wrong. The case by way of an example, which I'll use in relation to the New York Convention, is a case in which I was appointed as chairman of a CTAC tribunal. And as you probably know, the China International Economic and Trade Arbitration Commission is one of the world's major arbitral institutions. In the case in which I was appointed, a dispute arose as to which of 2 arbitral tribunals were the relevant institution for the purposes of the parties' contractual agreement to arbitrate, and secondly, which city was the seat of the arbitration. One party argued that the relevant arbitration institution was the Shanghai International Economic and Trade Arbitration Commission, and that the place of arbitration was Shanghai. The other party contended that the relevant institution was the China International Economic Trade Arbitration Commission, based in Beijing. So Beijing was the city, which was the seat of the arbitration. Now that dispute came before the Shanghai No. 2 Intermediate People's Court of the People's Republic of China. And the court sided with the Shanghai institution, which amongst its various names was the Shanghai International Arbitration Center. And what the court said was this, that the arbitration clause in the agreement matched the rule of Article 16, Section 2 of the PRC arbitration law, and that the Shanghai institution is the legitimate organization and has the authority to render the arbitral award. Consequently, the agreement involved in this case is effective. The dispute should be accepted by Shanghai International Economic and Trade Arbitration Commission. The question I raise as a matter of interest is, let's say the tribunal had proceeded to a hearing and issued an award on the basis that the CTAC Beijing was the relevant arbitral institution and that Beijing was the relevant seat. Would such an award have been challengeable under the New York Convention, under those two provisions I've mentioned, Article 5.1a or 5.1d? And I think the answer to that is probably yes. Next, I'm going on to the Arbitration Act 1996. I think Paul has mentioned sections 100 to 103 of the English Arbitration Act follow the wording fairly closely of Articles 5 and 6 of the New York Convention. But there are specific provisions in the English Act dealing with challenge. Section 68 deals with challenges based on serious irregularity affecting the tribunal, the proceedings, or the award. And then Section 69 deals with challenges based on points of law. But looking at Section 68, I'll just take two. There are nine grounds for challenge, but I'll just take two of them relevant to the case that I'm going to refer to. One is failure by the tribunal to comply with Section 33 of the Act. That's the general duty of the tribunal to act fairly. And B, the tribunal exceeding its powers. Section 68.3 then provides that in those circumstances, the court can either remit the award to the tribunal or set the award aside, or declare the award to be of no effect. And the case I illustrate is one in which I was instructed as counsel by a Paris law firm and then a London law firm. And the application related to a challenge in Queen's Bench Division in an ICC case, ICC award. The case is General National Maritime Transport Company and STX France SA. And we were acting for General National Maritime, which was a Libyan party. And when Mr. Justice Blair came into court in the commercial court, he mentioned that his brother was a former prime minister who had had some dealings with Libya, and did anyone object to him hearing the case? Well, none of us did, and the case went ahead. And he set out the basis of the claim. He said the claim relates to a final award by an ICC tribunal under which the claimant, General National Maritime, was ordered to pay STX France damages, interest and costs under a shipbuilding contract. And we sought, as claimant, we sought an order remitting the award to the tribunal, or alternatively, an order setting aside the award. Mr. Justice Blair set out the basis of our challenge to the award, which had been made at the hearing in Paris. And he set out our arguments. He said the claimant's case in summary is as to the manner in which the tribunal handled this situation. Although raised at an early stage of the proceedings, the claimant says in an unsatisfactory way, the tribunal did not resolve the non-production issue relating to a particular contract until the end of the hearing. It then ordered a redacted version of the contract to be provided against my party's objection. And then he sets out our challenge. Was the tribunal under pressure to complete the hearing in one day? Was it taking a shortcut by the last minute direction? Was it not an odd situation that the respondent's expert was shown the contract prior to the hearing, but it was not shown to the tribunal or to our lawyers, the claimant's lawyers? Was it acceptable for the respondent's counsel to let the claimant's lawyer, but not the claimant itself, see the contract? Was it acceptable in an international arbitration for the respondent's counsel to let the claimant's lawyers read a vital document, but not take a copy? The judge went on to set out his conclusions, which were against us. There's also a report of that case in Global Arbitration Review, a slightly more colourful view of the case. They said in their review, the English High Court has declined to set aside an ICC award in favour of France's leading builder of cruise ships, which resold a vessel ordered by the regime of Libya's former leader, Muammar Gaddafi, following the outbreak of the Arab Spring and the Libyan civil war. And it then goes on to say GNMTC, that was our client, ordered the 1,751 cabin cruise ship while still being built after Gaddafi's fourth son, Hannibal, suggested that the €565 million acquisition could kickstart a luxury cruise industry in the country. On completion, the vessel would have boasted 4 swimming pools, 26 lifts, a bowling alley, and 21 bars across 18 decks on the ship. I just
forgive me interrupting you, but and I know you've got a very interesting paper which everybody will see in due course. If you wouldn't mind dealing with the third case quite briefly, perhaps just identifying it.
Yeah.
That will give Jill time to.
Yeah, sure.
Q&A.
Yeah, I'll just mention quickly that in relation to challenges to under Section 68 and 69, of the challenges in the 3 years 2015 to 2016, there were 34 challenges in 1 year, 31 in another year, 47 in another year. In all those 3 years, only 1 succeeded. Anti-arbitration, anti-suit injunctions, they're set out in detail in my paper. I've referred to 2 English cases, Sabag and Guri, and Enka and Chubb, one dealing with anti-arbitration injunctions, one dealing with anti-suit injunctions. Both make it clear that the English courts have power to issue anti-arbitration injunctions and anti-suit injunctions. I've mentioned a case well, I'll given what the case illustration very quickly is this. It's a case in which I was appointed as sole arbitrator, and in the commercial court, to give a flavour of the view taken by the English courts, proceedings, anti-arbitration proceedings were issued in Nigeria and in England. Taking the English court, there's a report of Judge Waxman, and he said this in relation to a costs application. I have before me an application in relation to the costs incurred by the defendant in resisting what I regard as having been an entirely hopeless arbitration application. Putting it shortly, in that case, both the English courts and the Nigerian courts rejected the anti-arbitration injunction attempts. Quickly then, some conclusions in relation to those matters. There've been more than 160 states that have acceded to the New York Convention. I think that shows the extent of the success of international arbitration as a global dispute resolution process. I think the creation and the success of international arbitral institutions like the ICC and CETAC demonstrate the successful operation of the international arbitration process. One of the benefits of international arbitration is its confidentiality. The downside, of course, is that arbitration awards generally are not published, but nevertheless, I think it's fairly safe to say that probably most international arbitrations are conducted successfully, and that the awards are made by arbitral institutions are in fact carried out. But where there are challenges to the process, the challenge procedures are available under the New York Convention, under the English Arbitration Act, and there are methods of challenging by way of anti-arbitration injunctions and in relation to anti-suit injunctions. And Stephen, I'll leave it there. Thank you.
Thank you very much indeed. Thank you. And just to remind everybody that papers relating to the talks that you've been hearing, together with a link to the recording, will be circulated to everybody after the present proceedings. So we come finally to Jill Barrett, who for many years was a legal counsellor at the Foreign and Commonwealth Office in London, and is a well-known specialist in public international law. She's now a consultant advising on questions relating to treaty law and practice of various kinds. But for this morning's purposes, she has very kindly agreed to act as a discussant and perhaps to comment on one or two of the issues that have been raised in the talks, and maybe to ask one or two penetrating questions as well. So, Jill, I will hand over to you as our final speaker before we come to questions that anybody else wants to ask. Jill, you're on mute at the moment.
Thank you, Stephen, for your kind introduction. So I wondered if I could go back to some of the issues that Paul raised in advocating international arbitration as a solution to Brexit enforcement issues. Paul said there were no enforcement problems within the EU in principle. The Court of Justice already recognises the value of arbitration in intra-EU disputes. And he also thought that the issues of EU law would come up rarely. So I wondered if I could delve a bit further into that and ask Paul if he could elaborate on when he thinks the issues of EU law might arise in a novel way as a result of the EU fully leaving. I mean, it seems to me if EU law arises as the applicable law in an arbitration, then it would just be applied in the normal way. But so what does he see as the new issues? And I'm also would question why he thinks that it would be so rare. And I suppose it just strikes me that statement as surprising, given that the competence transferred under the Lisbon Treaty from the member states to the EU for investment treaties. And I'd also like to, in a sense, link Paul's with Anthony's themes and ask not only to what extent are anti-arbitration injunctions actually granted in investor state arbitrations, but also could the ECJ issue anti-arbitration injunctions or some kind of ruling that would have similar effects. So just to elaborate on that, I've already mentioned the Lisbon Treaty's transfer of competence for foreign direct investment. And we've also had the, following from that, the ACMEA judgment of 2018, now followed by the EU termination agreement of May 2020, so that there are no longer the intra-EU bilateral investment treaties, and henceforth it's EU law that governs the intra-EU disputes. And not only that, we have the EU taking over the negotiation of BITs with third states. And already the EU's concluded, I think at least 4, Singapore, Vietnam, Mexico and Canada have been concluded. Maybe there are more recently than that. So I'd be surprised, given that, if EU law wasn't going to crop up quite often in international arbitration of disputes under investment treaties. And I also wonder then whether the ECJ might issue rulings that have a similar effect to anti-arbitration injunctions. Now, bearing in mind, if I go back to a case I was involved in, which was the Mox plant arbitration between Ireland and the UK brought under two different international treaties. That resulted in infraction proceedings brought by the Commission against Ireland for having improperly taken that dispute to arbitration under two treaties, and Ireland lost. And as I mentioned, there's also the more recent ACMEA judgment. So if the ECJ makes rulings of that kind, effectively that may have the effect of ending the international arbitral proceedings. So be very interested in your comments, the panel's comments on that possibility. Also the capacity issue, I think it was Paul that raised that. He asked whether arbitral tribunals would have the capacity to deal with EU law issues. I think he linked it to after the UK leaves, but I would have thought, given how many treaties the EU is now negotiating with other countries on investment, and I mentioned 4 already concluded, but I believe there are a number more in the pipeline, surely the top lawyers of those countries, and China and India and the United States, are probably already well versed in EU law, and I would be surprised if you'd have difficulty finding suitably qualified arbitrators to be on any panel. But maybe that's not what Paul meant, so perhaps he could elaborate on that. Now, just moving on to the other issue, the due process, the right to be heard in virtual hearings. And Cemco's presentation I thought was fascinating there, particularly as the ICJ seems to have moved rather seamlessly to virtual hearings in June this year, and they didn't seem to feel the need to enact lots of new rules to deal with it. But perhaps issues arise more frequently in international arbitrations and court proceedings. So I wonder if the sort of thing that Cemco had in mind was what happens where, for example, you have technical breakdowns in proceedings. What then happens when you don't know why the screen suddenly went blank and the sound disappears? And supposing that happens at a rather delicate moment where the witness is giving evidence and perhaps is struggling with a question, how does the tribunal deal with that? And what if it happens more than once and there's a suspicion that perhaps it wasn't just a technical problem? And more generally, I think, do you see a lot more challenges to arbitral awards being brought under the New York Convention rules as a result of virtual hearings and completely new issues arising that perhaps are not covered by existing rules and don't normally happen in in-person proceedings? So, well, I think that's probably enough for now, Stephen.
Thank you very much, Jill. That's a useful menu of issues to enable us to go back to some of the speakers and invite them to comment. So, Paul, as I mentioned earlier on, your presentation did raise some questions, I think, some of which Jill has touched on. That's not a criticism, on the contrary, it's an indication of the range and the depth of the points that you made. So let me simply hand back to you for a few moments to comment on any of the issues that Jill has mentioned and answer those questions that you would like to deal with.
Yeah, thanks, Stephen. Thanks, Jill. There's quite a lot in that. Maybe if I'll do my best to comment on some of the issues, and maybe if I take it backwards, if I can. The reference to capacity that I made is a reference to issues that might arise after January 2021 in circumstances where the Court of Justice has already said that in principle, intra-EU arbitration is okay, providing the court of a member state can review the arbitration such that, if necessary, it can be the subject of a reference to the CJEU. And obviously, that wasn't the case in the context of the arbitral tribunal in ACMEA. And the concern, I suppose, that I have is that if an arbitration is seated in London, and then it is sought to be enforced in another member state, then the question that might arise is whether or not that member state can, in light of the fact that the arbitration is governed by English law, refer a question to the Court of Justice for a preliminary ruling. And I think that's potentially a difficulty if what is also an issue is some issue of European law. And I can see, it's true to say that in what I would regard as standard, if there is such a word, forms of a commercial dispute, but purchasing, selling, all that kind of stuff, that's the context in which I thought that the capacity of EU law to intervene or to be part of the dispute was relatively rare. Of course, there are significant regulatory obligations for compliance as a matter of EU law in areas like insurance and financial services and consumer protection and so on, although they may not really trespass too much into the area of significant international arbitral disputes or significant international disputes. It's true to say that bilateral investment treaties do give rise to those sorts of issues, and invariably, and I'm nowhere near as familiar with the territory, Jill, as you are. Invariably, as I understand it, the treaty itself purports to contain some form of dispute resolution mechanism, typically some form of arbitration, although the EU has sought in certain of the treaties, as I understand, or conventions or treaties, as I understand it, to try and impose some form of analogous or capacity to rely upon or take into account judgments of the European courts. So that's a big area and a big issue. And it's undoubtedly the case that the EU will have to, or at some point will have to conclude some form of BIT with the UK. So I suspect there'll be quite a lot of debate about the nature of the dispute resolution mechanism that is to be applied as part of that. The other issue, I'm just trying to recall the first issue that you mentioned. Yeah, I know you also mentioned anti-suit injunctions. I'm probably better off to leave Anthony to talk about that. Because
should we go back to Anthony for a moment, and then come back to you if there's time?
Yeah.
So, Anthony, any thoughts from you on Jill's comments in relation to anti-suit injunctions?
Yeah. If I can take the anti-arbitration point first, I think there are anti-arbitration proceedings which have been brought in the context of investor state. There don't seem to have been very many. I mean, one I came across was British Caribbean Bank and the government of Belize, and I haven't read the case, so don't ask me what it's about. I think they're fairly rare there. In the context of England and the English Arbitration Act, I mean, the English courts have made it quite clear that they do have the power to issue both anti-arbitration injunctions in relation to arbitration proceedings, and they have the power to issue anti-suit injunctions in relation to proceedings. And I mentioned two cases, the Sabah case related to an arbitration in the Lebanon, and the Enker and Chubb case related to proceedings in Russia. So it may well be that there are more proceedings under the English Arbitration Act than there might be in the context of investor state. I think Jill also raised the question of whether the ECJ has power to issue injunctions, something similar to. Well, I won't attempt to answer that. I think Paul and Shamko are the experts there, and James. So I'm not going to try and answer that question.
Stephen, sorry, my apologies. That was the question that I omitted to come back to. From a procedural perspective, there isn't the capacity for the Court of Justice to issue that form of order, because under the preliminary reference procedure, the the case has to come from, or the question has to come from, a national or a member state court. So there simply wouldn't be the capacity for an anti-suit injunction or an order of that type to be issued by a European court, because that's not how the European legal order works. However, if you had a situation where an investment treaty or some form of international agreement was entered into between the EU and a third country, say the UK, and there was provision in that for some form of judicial, I'm not going to use the word control, but judicial involvement on the part of the Court of Justice, and I'd say that's probably a bit of a long shot in the context of the EU, then it is possible that they could be the subject of some form of application at that stage. But it's quite difficult to see procedurally, certainly under the treaty, how it could be done.
Thank you very much, Paul. Now we're nearly out of time, but I'm just going to ask Chemco and James if they'd like to make a very brief comment each in response to any of Jill's interesting queries. Chemco first, perhaps on the due process point that Jill raised.
Okay, thanks very much. I think I will be very brief. The answers to Jill's questions on my side would be that if there is anything like that, it's just try to agree with the parties to repeat this, and then just take the view about the credibility of such a person. You can do probably nothing more. One of the things that I was just thinking about in view of my experience is just to maybe prepare even better to the extent it is possible in the circumstances. And then, in fact, you need to move into technological issues and just, let's call this monitoring the connection, monitoring the breaches in connections and all this kind of stuff. Probably pretty difficult, probably possible to at least to some extent in big cases, not in a smaller one when you have just a package of, or you are using, let's put this briefly, Zoom, and that's it. On the other question, I would probably say no more problems than in a normal way. We are just going through the technical revolution or technological revolution. We are changing totally way of our thinking. There will be new things, but we will adjust and we will find solutions to that. And maybe as the summary, recently I'm just reading quite a lot about AI and the technology and how it is used in law. Recently was a very nice lecture of Professor Susskind in CARB. So these are the things that we need just to keep up to and just make sure that we are not the ludists, just as in the 19th century, destroying the toys, but we are just finding solutions. So
thank you very much.
That's all. Thanks.
Thank you. And James, I'm going to give you the last word.
Thank you. Well, I think that from an arbitration supporter's perspective, the EU's interference in particularly the Energy Charter Treaty arbitrations relating to renewables has been unattractive. And the current stance of the EU preferring alternative methods for dispute resolution different from arbitration is also something which from London that we might look on with a skeptical eye. I'm not suggesting that the EU's attitude to arbitration in investment treaties would be a sufficient reason to vote Brexit, although we are now just facing the reality of it. But I do think actually that the EU's current public image of arbitration is something which will be quite different from the UK's post-Brexit. And I actually think that it's a good opportunity for London arbitration to promote itself. Thank you.
Thank you very much. I'd like to thank very much all those who have joined us for this morning's webinar. As I said, we will be in touch with you after this. We'll be sending you, I think, a link to the recording. We'll be sending you those papers on which some of the presentations have been based. We very much appreciate it if you were to get back in touch with us, particularly if you want to explore in greater depth any of the interesting issues that have been raised. Inevitably, in an hour and a quarter, one can deal only relatively concisely with points, some of which are really quite technical and do deserve greater and wider discussion. So feel free to come back to any of our speakers and to engage in dialogue, or of course to contact us for any other reason if you'd like to do so. And we very much look forward to seeing you again early next year for the remaining 2 webinars in this 3-part series. Meanwhile, thank you very much and good afternoon.
Thank you. Goodbye.
Thank you.